Orlando G. Tongol versus Filipinas M. Tongol. GR number 157610, October 19, 2007. This is for persons and family relations, specifically on psychological incapacity. Doctrine. Mere showing of irreconcilable differences in conflicting personalities does not constitute psychological incapacity. Disagreement on money matters is not a sufficient ground to declare a marriage null and void. Facts of the case. This case was about the denial of the petition for a declaration of nullity of marriage, where the court held that the psychiatrist who conducted a psychological examination on both parties had failed to link the disorder of the respondent to psychological incapacity as contemplated under Article 36 of the Family Code. This was an original case for petition for declaration of nullity of marriage filed by herein petitioner Orlando Tongol against respondent Filipinas M. Tongol. At the regional trial court, the petitioner alleged that respondent is psychologically incapacitated to comply with her essential marital obligations. Said allegation was supported by an expert testimony of a psychiatrist who conducted a psychological examination on both parties. According to the psychiatrist, the respondent has an inadequate personality disorder and recommended that the marriage of the parties be annulled because otherwise both parties will only suffer. The petitioner also presented the testimonies of his sister and one of his employees. On the other hand, the respondent admitted that their marriage is a failure and efforts at reconciliation have been fruitless. However, she claims that their marriage failed because it is petitioner who is psychologically incapacitated to fulfill his obligations as a married man. Evidence for Filipinas only consisted of her own testimony. Both the regional trial court and the Court of Appeals dismissed the petition. On appeal before the Supreme Court, the petitioner raised, among others, the issue of whether the evidence presented supports the findings of the trial court and the Court of Appeals that the psychiatrist failed to state that the respondent's inadequate personality was grave, permanent, and incurable. Issue: whether the totality of the evidence presented in the present case is enough to sustain a finding that respondent is psychologically incapacitated to comply with her essential marital obligations. Ruling: no. The totality of the evidence presented in the present case is not enough to sustain a finding that respondent is psychologically incapacitated to comply with her essential marital obligations. In this case, the regional trial court and the Court of Appeals gave credence to the conclusion of the examining psychiatrist that respondent is suffering from inadequate personality disorder. However, both courts ruled that the behavior exhibited by respondent does not amount to psychological incapacity as contemplated under Article 36 of the Family Code on the following grounds. First, the psychiatrist failed to link respondent's personality disorder to the conclusion that respondent is psychologically incapacitated to perform her obligations as wife and mother. The court did not see how respondent's personality disorder, which according to the psychiatrist is inextricably linked to her feelings of rejection, would render her unaware of the essential marital obligations, or to borrow the terms used in Santos, to be truly incognitive of the basic marital covenants that concomitantly must be assumed and discharged by the parties to the marriage. Second, the psychiatrist also failed to fully and satisfactorily explain if the personality disorder of respondent is grave enough to bring about her disability to assume the essential obligations of marriage. Even granting that respondent's psychological disorder is serious, the fact remains that there is no evidence to prove that such condition is of such nature as to render respondent incapable of carrying out the ordinary duties required in marriage. Third, there is no evidence that such incapacity is incurable. Neither in her written evaluation nor in her testimony did the psychiatrist categorically and conclusively characterize respondents' inadequate personality disorder as permanent or incurable. The psychiatrist was not sure of the permanence or incurability of respondents' illness as shown in her statement where she said that such illness is more or less permanent. Fourth, the psychological incapacity, as understood under Article 36 of the Family Code, must be relevant to the assumption of marriage obligations, not necessarily to those not related to marriage, like the exercise of a profession or employment in a job. In the present case, the testimonies of both petitioner and respondent, as well as the other witnesses regarding the spouse's differences and misunderstanding, basically revolve around and are limited to their disagreement regarding the management of their business. Fifth, marital obligation includes not only a spouse's obligation to the other spouse, but also one's obligation toward their children. In the present case, no evidence was presented to show that the respondent had been remiss in performing her obligations toward their children as enumerated in Article 220 of the Family Code. Thus, the court found no error in the findings of the Regional Trial Court as affirmed by the Court of Appeals that the aversive behavior of petitioner and respondent towards each other is a mere indication of incompatibility brought about by their different family backgrounds as well as their attitudes, which developed after their marriage. In sum, it is not disputed that respondent is suffering from a psychological disorder. However, the totality of the evidence presented in the present case did not show that respondent's personality disorder is of the kind contemplated by Article 36 of the Family Code, as well as jurisprudence, as to render her psychologically incapacitated or incapable of complying with the essential obligations of marriage. Therefore, the totality of the evidence presented in the present case is not enough to sustain a finding that the respondent Filipinas M. Tongol is psychologically incapacitated to comply with her essential marital obligations. In applying the foregoing, the petition was denied and the Court of Appeals decision and resolution were affirmed.